Hi everyone, welcome to Adamya Academy YouTube channel. So till yesterday we have discussed about the questions about related to jurisprudence. Now we will be continuing about the questions which are expected to come in the recent years. So let's start. Who among the following is called Darwinian before Darwin and sociologist before sociologist? The options are Savigny, Friedman, Bentham and Pound. So he asked, Darwin is a very famous person you all might be knowing. So the answer to this question is Savigny. But you probably will be thinking that Savigny is not a sociologist. Then how he is the answer to this question? Because Savigny was much before his time and he propounded the theories much better than sociologists of that time. So even if he is not belong to sociology, school of sociology, then also he is considered to be the Darwinian before Darwin or sociologist before sociology. So Savigny belonged to historical school, then also he is considered Darwinian before Darwin and sociologist before sociologist. This is a very famous question which have been asked in past years many times. According to which jurist, there are some kinds of law which, though not commands, are still within the provinces of jurisprudence. So, the options are Bentham, Fuller, Muller, and Austin. So, when I was teaching you Austin, an analytical school of jurisprudence, under that I have told you what books Austin has written. So the books he has written are Provinces of Jurisprudence Determined, which is one of his book. So here the keyword is the Provinces of Jurisprudence. So the answer will be Austin. Social utilitarian theory was propounded by Ehring, Ehrlich, Duguid, or Pound. I told you the meaning of utilitarian in the previous class, which means maximum benefit to maximum people. So I gave you an example in which there was a trolley and two people are being killed. In the case, the trolley is moved over them, and on the other road, 6 people are dying. So what will be the trolley driver doing? He will be taking his trolley towards the 2 people so as to save the 6 people on the other side. So this is what social utilitarian theory states, that we should see that maximum benefit is given to maximum people. So this social utilitarian theory was given by Ehring. But remember, utilitarian theory had been given by the father of jurisprudence, Bentham, and social utilitarian theory has been given by Ehring. Next question, who among the following is the author of the book The Morality of Law? So here, on the first place, it is written morality. You all might have heard a famous debate of Hart versus Fuller. It's the famous debate on law versus morality, that whether law should be taken on the upper edge or whether moral values should govern the society. So, in this famous debate, Hart always emphasized on law, whereas Fuller emphasized on the moral principles. So this book will be obviously be written by Fuller. So the answer to this question is Fuller. Who tested every law by the criteria whether it leads to the greatest happiness in the greatest number? So just before the previous question, I have told you what Bentham has written. What is the theory of Bentham? His theory is utilitarian theory. by Bentham, which states that one should see how much maximum people are benefited instead of seeing the welfare of very less people or some individuals. So society as a whole should get benefited from the law or the policies which government in time to time gives us. So the law by the criteria whether it leads to greatest happiness in the greatest number is nothing but utilitarian theory given by Bentham. So the answer is B. Bentham. Positive law is called positive law because it is made as the result of divine providence, made as the result of collective effort, made by the person in authority, or followed by everybody. So when I was teaching you Analytical School of Jurisprudence, we came across Austin, who has this very famous theory which states that command of sovereign backed by sanction. So in this case, positive law is nothing but authority. The law which has some authority, some legal sanction behind it, so that citizens have to follow that law irrespective of that social circumstances or the conditions prevailing. They have to follow just because sovereign has told it. So they have to follow law as it is. So this was given by Austin, and the answer to this question is made by the person in authority. Calson's theory of law is called pure theory because purely discussed jurisprudence only defined law in accordance with morality and purity. It is universal and separated from religion, ethics, sociology, and history. Discussed law purely in terms of justice. So when I was teaching you about the various schools, in analytical school, Calson is also there. So Calson gave a very famous theory which is pure theory of law or pure science of law. So according to pure theory of law, it means that law is free from all religions or from all social conditions, from all economic conditions which are prevailing. So one should, for law to be pure, it is very important that it should be free from any societal or any conditions which can make it impure. So this is what Calson theory of law, pure theory, means. So it is universal and separated from religion, ethics, sociology, and history. Because Calson considered that if we are considering all the conditions, then it may lead to law being corrupt or law being not able to serve the purpose, or law it will have evil of its own. So to avoid that condition, Calson suggested that one should consider law as pure. So he gave pure theory of jurisprudence. Who opined that law grows with the growth and strengthens with the strength of people and finally dies away as a nation loses its nationality? He is a very famous person who is generally the answer to many questions related to historical school. So this is the hint which I have given you. So the answer to this question is Savigny. In it, according to whose custom not only precedes legislation but is superior to it. So I have told you what historical school and analytical school have to tell about custom. Analytical school considers custom not to be a valid source of law. Whereas historical school considers custom to be a valid source of law. So according to Austin, custom is not a valid source of law, whereas according to Savigny, custom is a valid source of law. So custom not only precedes legislation but is superior to it. So in this condition, it is asking that In which school is custom given importance over legislation? So the answer to this question is historical school, and the propounder is Savigny. Which one of the following schools of jurisprudence laid emphasis on the question, how did law come to be? Analytical, sociological, historical, philosophical. So we have discussed about an analytical school, that how law should be, how law as it is. It discussed law as it is. Sociological school discusses the role of society with law. Historical school suggests how law should be. How did law come to be? Whereas philosophical school discusses about the three questions, how, when, and why the law has come into picture. For example, let us take any case law or any landmark case in which the theory has been propounded. For let's say, for example, if we take MC Mehta versus Union of India, which is a case on environment pollution. So in this case, we will see that how means why this case arose. It arose because they were the people, the industrialists, were not applying to the conditions for which the pollution was increasing beyond a particular limit. When it came because of the industrialization which is at the largest scale is being done. And why? Because there was a need of a law to regulate the pollution and the conditions associated with it. So the answer to this question is historical school. Law was deemed in terms of balancing various interests in the society, and as such law was described as social engineering by. So this I have told you in the previous class very elaborately. What does social engineering mean? Social engineering actually have 6 to 7 presumptions which are there, which relate to 6 to 7 presumptions how should individuals interact with each other? What is the general will? What is individual will? It talks about the various things related to interaction of individual outside his home, in his society. So this is what social engineering tells us, which we will study elaborately in sociological school. So social engineering is given by a very famous person which is named as Roscoe Pound. Who said jurisprudence is science of the first principle of civil law? So when I was teaching you about various schools, we came across a very famous person known as Salmond, who belonged to analytical school of jurisprudence. So what did Salmond have to say about jurisprudence? That it is the science of first principle of civil law. So there I have told you two keywords related to it. First one was principle, and second is civil law. So Salmond is the only person who talks about principles as well as civil law. So the answer to this question will be Salmond. Which one of the following is not correctly matched? Savigny, natural theory, Rawls, sociological school, Henry Meal, historical, all are correctly matched. So Rawls belonged to sociological school. Henry Meal was the founder of historical school. So of course he will belong to historical school. And Savigny was the founder of historical school. Mean was the founder of sociological school. So the wrong answer here is Savigny. Who appoint law and state are the same? एक minute. Who find law and state are the same? So the options are Calvin, Montesquieu, Pound, and Savigny. So Savigny belonged to historical school, Pound to sociological school. Calvin belonged to analytical school. Here the answer is Calvin. This we have to learn. There's no reason behind it. Which one of the following concept does not belong to sociological school of jurisprudence? Public interest, social interest, command, and juror postulates. So the command theory has been given by John Austin. His famous theory was command of the sovereign backed by sanctions. So in this option we can see command, which was a very famous word used by Austin of analytical school. So of course it will not be associated with sociological school. So the answer to this is command. And sociological school always looks into the public interest as well as social interest because it looks into the interest of individuals in interacting in the society. Who propounded the concept of living law? So the answer to this question will be Ehrlich. Ehrlich is also the founder. Can you remember of which school was he the founder? Austin was the founder of analytical school. Henry Maine was the founder of sociological school. And living law as a living organism was told by Ehrlich. Similarly, another person told society as a living organism. Who was it? Who said laws may differ from the commands of the sovereign because they may apply to those individuals who enact them and not merely to other individuals. So, in a very famous debate of Hart versus Muller, where Hart emphasized on law and Muller emphasized on morality, Hart considered law as supreme and guiding principle, whereas Muller considered morality to be supreme. So, in it, it is written that laws are supreme. It means what Hart has to tell is the answer. So, H.L.A. Hart is the answer to this question. Who among the following opined that jurisprudence was designed to defend the stability of a particular economic system and protect the interest of middle class? So here you will rather wonder that a person who has just talked about the interest of the sovereign has also talked about interest of middle class here. So this is a big hint which I have given you. So the answer to this question is Austin. The statement that precedents are the past decisions which were used as guide in the molding of future decisions is attributed to. So who gave the definition of precedents? Generally, precedents are the judgments which are taken by subsequent courts in their decisions, in their judgments, so as to avoid any ambiguity as well as not to waste the time of court as well as of lawyers. So, the statement that precedents are the past decisions is given by Dias, who is also a jurist. So, generally jurists and lawyers argue and discuss about various decisions. So, the answer is Dias. Custom as a source of law comprises legal rules which have neither been promulgated by legislation not formulated by professional trained judges, but arises from popular opinion and is sanctioned for long usage. Who said it? So I have told you that there are two schools related to custom, which considers custom as a valid source of law, and another school considers law as morality as a valid law as a custom as not a valid source of law. So analytical school did not consider custom as a valid source of law, whereas historical school considered custom as a valid source of law. So here custom as a source of law is the key word. And who considered custom as a source of law? Of course, Maine. So the answer to this question is C. Who defined law as the abstract expression of the general will existing and for itself? So here the key word is abstract expression. And who has told law as the abstract expression of the general will, which is existing in for itself? So the answer to this question is Hegel. Who among the following is the author of the book Social Dimensions of Law and Justice? So here there are four options: Radcliffe, Lon Fuller, Muller, and Julius Stone. So the keyword here is law. So who talked about law? I have told you that there's one trick to remember this. Julius can be told as jurist, can be told as lawyer. So here, who talked about this is Julius Stone. The answer is D. Bentham's philosophy is called. It's a very bonus question. We have discussed it so many times. Bentham gave a very famous theory known as utilitarian theory, which states that maximum benefit to maximum people should be looked into. Law should always try to give maximum benefit to the people, but in the cases where law has to bring some society up in some group of people upward in the society, it can serve for the benefit of less number of people. But in a general sense, in a general way, law always seems to serve the maximum people. So law is for the maximum benefit of maximum people. Law as such is not made but found. It is to be found in popular faith, common conviction, customs, traits, habits, tradition, which in course of time grow into legal rules. This concept was propounded by. So, this is a very famous person who generally is the answer in most of the questions. So this is a very big hint which I have given you. So who has told that law is found? The person who has founded the historical school of jurisprudence has told that law is not made, it is found. It means when we study history, we see what conditions were prevailing at that part of time, and now what are the conditions in the modern society. So we try to make law so as to make it more related to the present conditions of the society. So, in this case, Henry Maine is the answer. Were there is a law where human conduct is made in some sense no optional or obligatory. This was said by which jurist? So here also he is emphasizing on law. So in a very famous debate of Hart versus Fuller, Hart emphasized on the obligation of law, whereas Fuller emphasized on the ethics and morality. So the answer to this question will be actually Hart. Who among the following authored the famous book De Legibus? have told you about the phases of development of Natural School of Law. So there we have studied 4 stages of development, in which we have studied ancient phase, medieval, Renaissance, and modern. Ancient phase considered natural conditions, medieval, the church, Renaissance, decline of church. So, Cicero belonged to which stage? He belonged to the ancient stage, and Cicero also wrote a famous book known as De Legibus. The answer to this question is De Legibus. Who among the following is associated with formal analysis of the structure of English law? So here we have to take into consideration 2 words, formal and English law. Who is the father of English law? John Austin is the father of analytical school of jurisprudence, or we can also say he is the father of English law, English jurisprudence. So the answer to this question will be Austin. But we have also studied that Holland was a disciple of Austin, and he studied about the formal structure in jurisprudence. He laid emphasis on the formalization of law, that citizens should also know why the sovereign has made such a law and what will be the impact on them regarding that law. So, but here Holland is not in the option, and we have a word, very common word, English law, which has been specifically used by Austin. So the answer to this question will be Austin. According to who, the jurisprudence is knowledge of laws. So when I started with my first class, I am told what is the meaning of jurisprudence. Juris means law, and prudence means, which comes from a famous word, prudentia, which means knowledge of law. So, who gave this famous definition or famous meaning of jurisprudence? It was given by Kelsen. In India, grand norm is. So when we were discussing about grand norm, I told you that the basic, that for a law to be made, there are certain guiding principles or basic principles which have to be looked into. These basic principles are called norms. So we can consider the Constitution of India as the basic norm or the basic guideline on which other laws are placed. So they have to follow the Constitution of India. So in India, grand norm is Constitution of India, which is of course the landest constitution in whole of the world. The concept of rule of law in India and due process in USA is essentially based on which of the following? Positive law approach, realistic approach, natural law approach, and social solidarity approach. So you might have heard about Article 21 as well as Article 14. What does these sections or these articles of Constitution tell us about? Article 21 is about right to life, that no person will be deprived of his life as well as personal liberty except according to procedure established by law. And Article 14 tells about equality before law. So in India, we can see that we consider all people to be equal. There is no biasness as to what they will get in relation to the professional job or any social security. So this concept of rule of law in India and treating people equally is a basic principle or basic human instinct, and thus is related to natural laws approach, which actually focuses on the basic human instinct. Who among the following is the author of the book Law, Liberty and Morality? So this we have to learn that H.L.A. Hart is the author of the book Law, Liberty and Morality. As we have discussed that Hart versus Fuller debate talks about law and morality. So in this book also we find the two words law and morality with liberty. So the answer to this question is H.L.A. Hart, who said that every legal action has moral dimension. So whenever a legal action is taken, morality is also kept in mind, because when a law is formed, it generally revolves around the morality and the moral principles which are being laid down in the society. So this was told by Dawkins. This also we have not discussed in detail, but we have to learn that every legal action as moral dimension has been told by Dawkins. So this is all what I wanted to tell you about the previous year questions as well as expected questions which will be there in your future exams. So till then you can revise the questions and stay tuned for next class. Okay, bye.